Supreme Court showdown: can a U.S. president fire a Fed governor by social media? Good evening and welcome to GAF, Global Affairs Forum. I am your host, Rebecca Lawson, and this is World Analysis, where global consequences matter. Tonight, we examine a case before the U.S. Supreme Court that could reshape the balance of power between presidents and independent institutions. Can a central bank governor be removed by a social media post? And what happens when politics collides with monetary independence? This case reaches far beyond one individual, one presidency, or even one country. At its core, this is a confrontation over executive power, due process, and the independence of the world's most influential central bank. The United States Supreme Court is now weighing whether President Donald Trump can remove a sitting Federal Reserve Governor, Lisa Cook, by announcing her dismissal on social media. According to Reuters, the justices are set to hear arguments on Trump's request to lift a lower court injunction that has temporarily blocked Cook's removal while her legal challenge proceeds. A dismissal by post, not process. The facts themselves are extraordinary. Late on the evening of August 25th, President Trump posted a letter on his Truth Social account addressed directly to Cook stating, "You are hereby removed." No prior notice. No formal hearing, no administrative process, just a social media declaration. In the 111-year history of the Federal Reserve, no president has ever removed a sitting Fed governor. The central bank was deliberately designed, under the Federal Reserve Act of 1913, to be insulated from short-term political pressures, especially pressures tied to interest rate policy. Cook, appointed in 2022 by former President Joe Biden and the first black woman to serve as a Federal Reserve governor, argues that Trump's action violated the Fifth Amendment's guarantee that no person may be deprived of liberty or property without due process of law. Lower courts agreed. U.S. District Judge Gia Cobb ruled that Trump's attempt to remove Cook likely violated constitutional due process standards and failed to meet the statutory for cause requirement under the Federal Reserve Act. The D.C. Circuit Court of Appeals declined to intervene, forcing the administration to seek relief from the Supreme Court. The allegations and the politics behind them. The administration's justification hinges on mortgage fraud allegations raised by Federal Housing Finance Agency Director Bill Pulte, a Trump appointee. Cook denies the accusations and argues they are a pretext, not a genuine legal basis for removal. Her lawyers contend that the real motivation is policy, not misconduct. President Trump has repeatedly demanded lower interest rates and has publicly criticized Fed Chair Jerome Powell for resisting political pressure. In a parallel move that has alarmed economists globally, the Trump administration recently opened a criminal investigation into Powell over testimony related to a Fed building renovation, an action Powell himself described as an attempt to exert influence over monetary policy. Taken together, these actions suggest a broader strategy, reasserting presidential control over an institution explicitly designed to resist it. Due process versus presidential authority. Before the Supreme Court, the case raises two deeply consequential questions. First, what does "for cause" actually mean when Congress does not define it? Second, does a public official have a constitutional right to due process before being removed from office? The Trump administration argues no. In its filings, the Justice Department claims that government officers do not possess a property right in their positions and therefore are not entitled to due process protections. It further argues that Cook received sufficient notice when Trump posted days earlier that she must resign now, and that her failure to publicly respond constituted an opportunity to be heard. Legal scholars are unconvinced. Professor Jane Manners of Fordham Law School notes that historical precedents point toward judicial-type hearings, including evidence and testimony, when removals are contested. As Judge Cobb observed, it is doubtful that a constitutional process can be assembled from scattered social media posts and news articles. A global comparison: how other democracies protect central banks. This dispute is being watched closely well beyond U.S. borders. In the United Kingdom, the Bank of England's Monetary Policy Committee members cannot be dismissed unilaterally by the Prime Minister for policy disagreements. Removal requires clearly defined misconduct and formal procedures. In the Eurozone, European Central Bank board members enjoy even stronger protections. Dismissals can be reviewed by the European Court of Justice, explicitly insulating monetary policy from national political pressure. In Canada, the Bank of Canada governor is appointed for a fixed term and can only be removed for cause, with significant institutional safeguards and political norms discouraging interference. Contrast this with countries where central bank independence has eroded, Turkey, Argentina, or Zimbabwe, where leaders have dismissed governors to force lower rates, often triggering currency collapse, inflation spikes, and capital flight. The United States has historically aligned with the first group. This case risks placing it closer to the second. Why markets, mortgages, and the world are watching. The Federal Reserve is not just America's central bank. It is the anchor of the global financial system. Its decisions ripple through mortgage markets, sovereign debt, exchange rates, and inflation expectations worldwide. Any perception that Fed governors can be removed for political reasons raises fears of policy instability and inflationary bias. Even the process matters. If dismissal can occur via social media without hearings or evidence, the chilling effect on dissenting policymakers could reshape how monetary policy is debated internally, quietly narrowing the range of voices at the table. A court with options and consequences. The Supreme Court, now with a 6-3 conservative majority, could resolve this case narrowly, focusing on procedural due process failures without defining the full scope of presidential removal power. Such an outcome would preserve Cook's position for now, avoid ruling directly on Fed independence, and defer the hardest constitutional questions. But even a narrow ruling would send a powerful signal. Process still matters, even in an age of digital governance and executive social media decrees. And yet, the broader issue remains unresolved. How resilient are democratic institutions when norms collide with raw power? As this case unfolds, it is no longer just about Lisa Cook, Donald Trump, or the Federal Reserve. It is about whether modern democracies can maintain institutional guardrails in a political era defined by speed, spectacle, and centralized authority. What happens next, however, may prove even more consequential than the procedural arguments now before the court. At stake is the precedent the Supreme Court sets, not just for this presidency, but for every future administration tempted to blur the line between political authority and institutional independence. Even a narrow procedural ruling, while preserving Governor Cook's position for now, would leave unresolved the deeper constitutional tension over how far presidential power extends into independent agencies. According to Reuters, the justices could decide the case on due process grounds alone, focusing on whether a dismissal carried out via social media satisfies constitutional standards, without defining the outer limits of for-cause removal under the Federal Reserve Act. That path would allow the court to avoid a direct confrontation over the Fed's autonomy, while still reinforcing the importance of formal process. But legal ambiguity carries its own risks. The normalization of governance by social media. One of the most underappreciated dimensions of this case is not monetary policy, but governance style. Presidential use of social media to announce policy decisions is no longer novel. What is novel is using it to terminate a constitutionally protected office holder at the heart of the global financial system. If upheld, this approach could normalize a model of governance where digital declarations substitute for institutional procedure and where public posts become instruments of executive action. Lower courts have already signaled discomfort with this trajectory. Judge Cobb's ruling emphasized that constitutional notice cannot be improvised from a scattered assortment of social media posts and news articles, a warning that resonates far beyond this specific dispute. In practical terms, this raises unsettling questions. How are officials meant to respond? Through press conferences? Through posts of their own? Through silence interpreted as guilt? None of these answers align comfortably with constitutional norms. Monetary policy under pressure, a fragile equilibrium. From a global financial perspective, the the timing of this confrontation could hardly be more sensitive. Major economies are navigating slowing growth, high debt levels, and fragile housing markets. Central banks, from the Federal Reserve to the ECB and the Bank of England, are walking a narrow path between inflation control and recession risk. Against this backdrop, political interference, real or perceived, can quickly destabilize expectations. History offers sobering lessons. In countries where central banks lost independence, markets reacted swiftly. Borrowing costs surged, currencies weakened, and inflation accelerated. Even in advanced economies, confidence is built on credibility, and credibility depends as much on institutional process as on policy outcomes. That is why this case is being scrutinized not only by legal scholars, but by bond traders, mortgage lenders, pension funds, and sovereign governments worldwide. Worldwide implications, a signal beyond Washington. International observers are asking a simple question. If the United States weakens the independence of its central bank, what message does that send globally? In emerging and developing economies, reformers have long pointed to the Federal Reserve as a model of institutional resilience. A ruling that appears to tolerate politically motivated dismissals, even indirectly, could undermine reform efforts elsewhere and embolden leaders who already view independent institutions as obstacles rather than safeguards. Conversely, a firm judicial insistence on due process and statutory limits would reinforce a global norm. Economic stability requires institutional restraint, even at the highest levels of power. The unresolved conflict between law and leverage. The administration's argument that no government officer has a property right in their office touches on a deeper philosophical divide. While technically persuasive in isolation, it clashes with decades of jurisprudence, recognizing that procedural fairness is essential when reputations, careers, and public trust are at stake. Cook's case illustrates this tension vividly. The mortgage allegations cited by the administration relate to conduct predating her confirmation, raising further doubts about whether they can legally constitute cause under the Federal Reserve Act, another issue the Supreme Court may sidestep for now, but cannot ignore forever. What to watch next? As arguments unfold, several signals will matter. Whether the justices question the adequacy of notice and hearing, or instead focus on presidential authority. How narrowly the ruling is framed, and whether it leaves room for future challenges. The reaction of financial markets, which may interpret even procedural rulings as indicators of political risk. Most importantly, the case tests whether democratic systems can adapt to new modes of communication without surrendering the safeguards that protect institutional integrity. This is not just a legal contest. It is a stress test of governance in the digital age, one that places the Federal Reserve, the judiciary, and the presidency on a collision course whose outcome will shape global expectations for years to come. And as the Supreme Court weighs its decision, the world waits, not only for a ruling, but for clarity on whether independence, process, and restraint still anchor the world's most powerful democracy, because beyond the courtroom arguments and the legal briefs lies a deeper institutional dilemma that no ruling can fully resolve on its own. The Supreme Court's institutional tightrope. For the Supreme Court itself, this case presents a delicate balancing act. On one hand, the court has historically been cautious about intruding into the president's authority over executive branch officials. On the other, it has repeatedly affirmed Congress's power to design independent agencies insulated from direct political control, especially where long-term economic stability is at stake. The Federal Reserve sits at the very center of that constitutional compromise. A ruling perceived as overly deferential to presidential discretion could invite future administrations, of any party, to test the limits of removal power, not only at the Fed, but across other independent bodies such as securities regulators, antitrust authorities, and consumer protection agencies. That would subtly but decisively shift the balance of power away from institutional governance and toward personalized executive control. Conversely, a strong affirmation of due process, even if narrowly framed, would reinforce the idea that independence is not a privilege granted by presidential restraint, but a legal safeguard enforced by the courts. A chilling effect inside central banks. Another under-discussed consequence lies within the walls of central banks themselves. Even without an outright dismissal, the mere attempt to remove a governor for alleged misconduct tied to policy disagreements introduces a chilling effect. Policymakers may begin to self-censor, avoiding dissenting views that could attract political retaliation. Over time, this erodes the quality of internal debate, the very mechanism that central banks rely on to avoid groupthink and policy error. Economists often emphasize independence as protection from politicians. Less discussed is independence as protection for honest disagreement. If governors perceive that disagreement with the executive branch can trigger public accusations, investigations, or abrupt removal attempts, the internal culture of policymaking shifts in subtle but dangerous ways. Financial markets read signals, not footnotes. Markets, too, are unlikely to wait for the fine print of the court's reasoning. Bond yields, inflation expectations, and currency markets respond to signals, not legal nuance. Even a temporary weakening of perceived independence can alter investor behavior, especially at a time when global debt levels are elevated and confidence remains fragile. Mortgage markets are particularly sensitive. The Federal Reserve's credibility directly influences long-term interest rates, housing affordability, and credit availability. Any perception that rate decisions could be politically coerced risks distorting these channels, with real consequences for households and businesses. This is why the case resonates so strongly beyond U.S. borders. The Federal Reserve is not merely a domestic institution, it is a global anchor, a test case for the digital presidency. There is also a structural question that extends well beyond monetary policy. Can constitutional governance adapt to the speed and informality of digital communication? Social media collapses the distance between decision and declaration. It rewards immediacy over deliberation and visibility over procedure. That tension is manageable when used for rhetoric, but far more dangerous when it becomes a vehicle for formal state action. If the Supreme Court does not draw clearer boundaries, future disputes may increasingly revolve around whether a tweet, post, or online statement constitutes binding executive action, and whether constitutional safeguards can realistically operate in that environment. This case, then, may become an early landmark in defining the rules of governance in the digital era. Global parallels and global warnings. Internationally, observers are already drawing parallels. In several countries where executive leaders consolidated power incrementally, institutional weakening did not occur overnight. It began with exceptions, justified as unique circumstances, followed by normalization, and finally by routine interference. Central banks were often among the first casualties. The United States has long stood as a counterexample, a system where even powerful presidents faced legal and institutional constraints. The Cook case tests whether that reputation still holds under modern political pressures. What remains unresolved, no matter how the Supreme Court rules in the coming weeks, critical questions will linger. What constitutes cause sufficient to remove a Federal Reserve governor? How much process is constitutionally required before reputational and professional harm occurs? And who ultimately polices the boundary between political accountability and institutional autonomy? These questions do not disappear with a procedural ruling. They merely shift to the next case, the next controversy, the next test of norms. For now, the court's decision, whether narrow or sweeping, will be read as a statement about how seriously the United States takes the idea of independent governance in an age of political polarization and digital immediacy. And as Washington waits for the justices' questions and eventual ruling, the broader world continues to watch closely, because what is being weighed is not just one governor's tenure, but the resilience of the institutional architecture that underpins global economic stability, which brings us to the moment where analysis must give way to reflection and responsibility. Advice to global citizens: why this case matters to you. For global citizens, this case may seem distant, technical, or confined to elite institutions in Washington. It is not. Central bank independence affects inflation, interest rates, mortgages, jobs, pensions, and currency stability. When institutions designed to buffer politics from economics are weakened, the costs are eventually paid by ordinary people through higher prices, unstable housing markets, and reduced economic certainty. Global citizens should, therefore, pay attention to institutional signals, not just election results. Resist the normalization of governance by spectacle, where power is exercised through platforms rather than procedures. Defend due process as a public good, not a privilege for elites. History shows that once institutional erosion becomes visible to everyone, it is often too late to reverse cheaply or peacefully. Advice to global leaders: restraint is strength, not weakness. For political leaders, especially those governing democracies, the lesson is even clearer. Independent institutions are not obstacles to leadership. They are shock absorbers. They protect governments from their own worst impulses and societies from policy whiplash. Leaders who respect institutional boundaries inherit credibility. Those who undermine them inherit volatility. Global leaders should take 3 lessons from this moment. 1. Process legitimizes power. Decisions reached through lawful, transparent procedures endure longer than those imposed through force or publicity. 2. Independence builds trust. Markets, citizens, and international partners trust systems that cannot be bent overnight. 3. Short-term control creates long-term risk. Political influence over monetary policy has repeatedly ended in inflation, currency collapse, and social unrest. The most successful leaders in modern history are not those who dominated institutions, but those who left them stronger than they found them. Final reflections: what this case truly represents. As the Supreme Court prepares to rule, the world is not merely awaiting a legal judgment. It is watching a democracy define its red lines. This case has revealed several enduring truths. Central bank independence is fragile, even in advanced democracies. Digital power can outpace constitutional safeguards if courts do not adapt. Due process is not a technicality, it is the backbone of legitimacy. Institutional erosion begins quietly, often justified as exceptional. Whether the court rules narrowly or broadly, the underlying struggle will continue between immediacy and restraint, personalization and institutions, power and principle. The real verdict will not come only from the justices' opinions, but from what leaders choose to do next and from what citizens are willing to defend. Because in the end, the independence of a central bank, the authority of a court, and the integrity of democratic governance all rest on the same foundation: a shared commitment to rules that bind everyone, especially those who wield the most power. This is Rebecca Lawson, World Analysis Global Affairs Forum, where we examine not just what is happening, but what it means for the world we share. As the Supreme Court weighs its decision, the world is watching, not just for a ruling, but for what it reveals about the future of democratic restraint. Because when institutions weaken, markets shake, and ordinary people pay the price. Thank you for watching GAF, Global Affairs Forum. If you value deep analysis beyond headlines, like, subscribe, and join the conversation. Until next time, stay informed, stay global.